Hmm.
Can I?
Uh-huh.
But there is left. Can I?
3 years bail, she will give a date because if tomorrow we are allowing, but not all the matters on tomorrow. Isn't it?
Yes, sir. Yes.
Numbered. Otherwise, it will be listed.
Below 7 years. No?
She will count how much matters are for tomorrow and then we'll distribute accordingly. For AB and BA. BA will get preference. Or AB anyway, mix kore diba. And up to 7 years, all are allowed. Bail, a BA and AB. Okay. No need to mention. Give the slip. She will accordingly decide which will go to which date. If all are listed tomorrow, suppose 15 additional matters, it will be difficult. Yes, next. Yes.
For 22. That is for
22, no?
Yes.
Yes. So here LCR is available.
We'll see. Wait. LCR is there. Wait. Is having any problem? Munir is having any difficulty? It's LCR, okay? When? Next week may not be possible. Adjourning and having a next week after vacation. It's a searched.
Yes.
Yes.
NDPS. What is the quantity?
It's 408
Heroin.
ganja.
Below the intermediate.
Intermediate quantity. Okay, when? Tell us. You are inside what to do. Yes. When? You should be ready with it at least a date. We are giving an option. 5th of December.
Lord, in item number 45 today, I filed one affidavit for it. If you're allowed to call that.
Item number?
45, ma'am.
What is this?
The preliminary revision.
No, why? What is the IA?
I, Lordship. Lordship, in this case, Lordship, Dibora is appearing. He's asking.
Oh, what about the IA? You are for the respondent or what?
My Lord. In the
call
preliminary
it, call
revision petitioner, mine.
Call it.
May I please lodge?
Hmm.
57, madam. In your not there, madam. Can you be on Friday, madam?
57.
Motion,
Motion.
madam.
57. Okay, it's a second. We'll call for the case diary.
Okay.
That's all.
Lord, and
You be there. We'll call for the case diary when matter reaches.
another prayer, my Lord, a document. So, my Lord, it is special like that. Regular bill for tomorrow or day after. Special like Lordship is taking up.
I'm
Oh,
taking.
yes.
No, bail also.
Bail also, yes.
Huh?
Yes. As per the roster, my Lord, APBA, special like
Special also given, madam.
Not bail. Bail is distributed, I think.
Bail is
Fourth bench is Lordship is a senior bench.
Okay. Okay.
Any date tomorrow, dear. Obliged.
That is you will decide. As per how many meters are fixed, how many meters we have already fixed. Yes.
Sir, that's praying for a listing of the
Hmm.
for
For what? Motion?
for a hearing.
That's not possible.
But we have challenged award by the I'm a wife, my Lord.
Hmm.
I put people for NS.
Hmm. Now that has been admitted.
Yes. Any date as per your Lordship.
You are getting the present maintenance.
Yes, my Lord.
So wait for some time because before vacation, hearing these kind of matters may not be possible. Since you are having some respite, you are getting something. Some are inside jail, so we'll give preference to them only at before this vacation.
Oh.
More particularly in hearing matters. Yes, next.
Okay.
May I please do Lordship? I beg to make item number
Item number?
31.
no, here city available, but city is not up to date. Up to 59 only, man.
Okay.
Yes, not up to date. So up to date city is
When?
up to 7th of December.
Or
Up to date.
up to the city. Any interim?
Intermission.
Interim to continue. Are you aware?
No.
Madam, come prepared when you want to make a mention. Taking the PP's cause list and taking an adjournment that no, I should not wait. CD is not there. It's not like that. Yes.
Ma'am, please, Your Lordship.
Yes.
I beg to mention item number 18.
Yes.
Person difficult if you have the AM for
Hmm.
for the day law.
Hmm.
They are inside of the HCR has also been
Hmm. So,
Can it be adjourned for the day? For the day. They are inside for the
okay, when do you want?
Can it be on 29th? There are more than 50 days inside.
It is here, you argue it.
Sir.
Why you delay your client's detention till
Okay.
29? You be here. You cannot have both. You'll seek an adjournment and fix a date as per your convenience. That is not permissible. Yes, 29 possible. Give a other date, not 29.
30th.
5th of December.
Highly obliged.
If I beg to mention item number 39,
Item number
39.
CD not available, my lord.
CD not available. Any interim?
Yes, interim is there.
Interim may be
Interim to continue. Date when, Mr.
My lord, 6th of December.
6th of
Pleasure, Lord.
Yes.
I beg to mention for the fixing of the date of the bail application, Lord. It is 6th of December. If it is listed on 6th of December, then the mandatory period will be over. It may be come up on the 29th of November.
Already a judicial order is there. They will have to bring the CD. These are the difficulties.
Last of the Lordship, Honor for 6th Lordship on 6th of December.
You ought to have tell this. There is a judicial order fixing a date that has been intimated to the PP. PP has intimated for the case diary. Now everything can it be sent orally. Mention memo is an oral submission.
And if
Yes, what you say.
My lord, provided the.
You do one thing. You have a talk with him and then make a mention tomorrow. You intimate him everything because ultimately he'll have to call for the case diary. Isn't it?
Yes.
Tomorrow, make a mention for tomorrow. Give him the details. Yes.
May Lord, I please, Your Lord.
Yes.
On my criminal petition matter, my Lord, admission matter, my Lord. Matter will fix the day after tomorrow, my Lord.
Which method?
My Lord,
Which method?
not fixed today, my Lord, for listing, my Lord.
Day after-
Admission matter, my Lord. Already, my Lord, matter,
Criminal appeal.
criminal, no, my Lord, criminal petition for quashing, my Lord, charge sheet, my Lord. And proceeding, my Lord. Already, my Lord, amicably settled, my Lord, admission matter, my Lord.
Amicably settled.
settled.
What are the offenses?
Offense for 376, my Lord.
376 amicably can be
Yes,
amicably be
already, my
settled.
Lord, matter has been state, my Lord, and thereafter, my Lord, some settlement took
Not
place.
day after tomorrow.
My Lord, then convenient to the court, my Lord.
4th of December. 4th
Obliged,
of,
my Lord. Much
give the
obliged,
date mention. Huh?
obliged, my Lord. Much obliged.
May please, Your Lord. Item number 38.
Yes.
Engage sound system. Yes, definitely.
38 is FR.
Final report submitted. Huh? B. Any interim?
Yes, need.
Okay, wait.
Hello, the actor to person. I am not the actor.
Okay, you need not be. We will pass the order. Yes.
May I please?
Yes.
I beg to mention for listing on criminal appeal.
Hmm.
If for motion method, can it be on Friday?
Hmm.
Come for admission.
Admission.
Appeal.
Criminal appeal. First,
Appeal
it is listed for first time, definitely. Yes. Criminal appeal for admission, no problem.
Not for the first time, Lordship. It was listed second time. Earlier, one occasion was listed, but unfortunately,
will-
that there was none.
Okay, anyway,
Yes,
it is for admission for the
Yes,
first
Lord.
time. Yes.
Appeal.
Yeah.
Lordship, I beg to mention listing of criminal appeal.
Hmm.
Club bearer also.
Hmm.
That has not been listed for the last. It's a these two are club bearer. These two are we fight against the TV case that was fight against that right.
Any stay?
Stay is there, but the recent development is that the parties are will compromise.
Other side appeared
Other side has appeared, but it has not been fixed for the 6 months.
thereafter.
At last order,
Okay. Okay, next week, give it. 5th of December.
okay.
May it please, Your Lordship. Your
Yes.
Lordship asked me to make a mention today. Yesterday I made it.
Ah.
There was a criminal petition, Your Lordship. Warrant has been issued.
has been fixed on 16th of December. Yeah,
Okay.
tomorrow, your lord.
16th of December, you have time. It will be on 8th of December. Yeah.
This is criminal revision petition.
Hmm.
This matter bail was granted on 10/11/23, my lord, by the Honorable Court,
Hmm.
and with some conditions. Accordingly, my lord, we have filed this condition, filed bail bonds before the learned session. However, learned session has rejected this.
Why?
Why, my lord? Two government securities, my lord. We have filed two government securities, but the learned session has come with a finding that the salary should be minimum one. That cannot be possible, my lord. So I have
Is there any condition?
condition, my lord.
Salary should be 1
No,
lakh.
no, no, my lord. Not like. Come with
Okay.
a
Okay.
by today, my lord.
Today.
Comply.
Number
May I please, your lord?
Yes.
I beg to mention item number 47.
Hmm.
But the matter may be withdrawn, lordship. By instruction of the petitioner, both the parties amicably settled.
Okay. It is submitted by the learned counsel for the petitioner that you are for the petitioner
Petitioner,
that the dispute arising out of the present petition, dispute connecting the present petition has amicably been settled between the parties, in as much as the dispute is between the petitioner, petitioners, that is father-in-law, mother-in-law, and husband, and the respondent number
number
2, that is the wife. So be that as it may, as the parties has amicably settled, the present revision petition stands closed. Interim order, if any, stands vacated.
But the one criminal petition looking for orders on 5th of the
Yes.
Criminal division for withdrawal melatonin date.
Give it that withdrawal.
criminal motion method. And it is 29.
What is the method of
That is for passing on.
passing of what?
370.
FIR.
No, no.
Okay. We'll call for the scan copy. Yes. When? No, she will give a date.
motion.
28. 20 is a working day.
My please, lord. I beg to mention for listing criminal petition, lordship, in orders to lordship. In
Why it should be listed in orders for what order?
lordship, service not yet complete, lordship. Respondent not yet appeared, lordship. And
Service not yet complete, respondent not yet appeared.
Yes.
So you want to take fresh date or what?
yes, lordship.
Yes. 24th.
Lordship, I beg to mention for listing criminal division section.
Hmm.
Lordship, this is the motion matter, and notice is not been yet.
Why this matter is adjourned on last occasion?
Yes.
Then you will take an adjournment and you will make a mention.
Lordship, the adjournment was export instruction
What instruction? By whom?
from the petition.
Now instruction is complete.
Yes.
Yes. Give it a date.
Listed on
1st of December.
Lordship, the case is based on lower court is 1st of December. May it be
Give a date on
28.
29.
May I please,
Yes.
I beg to mention item number 20, Lordship passes section 5.
20. Wait for some time. We'll instead of he will keep the date, we'll pass the order 20.
May I please, lord?
Hmm.
But in connection with item number 23,
Hmm.
we have filed an affidavit, my lord, that may be called for that
Affidavit by whom?
affidavit of a petitioner, my lord, regarding serving of justice service.
Okay. All
Obliged.
May I please, Lord?
Hmm.
I beg to mention criminal petition, which was last posted on 13/9/2020
Hmm.
for admission column. And
what happened on that day?
there was an interim order for us.
No. On 13/9, why matter was adjourned?
13/9/22.
23.
Why it was adjourned? Not aware. Come with the details. Yes, next.
That was I for character.
May I please, lordship?
CD has already been called for.
Yes, to the available.
It is available.
Lordship, I am a diabetes patient and
So that's
I
why bail
usually
should be
use
granted.
diabetes, Lordship.
Huh?
I usually use diabetes. I usually use the
You use
insulin,
diabetes, usually use diabetes. Well, you should sleep early.
Lordship.
You should sleep early. Go for morning walk in the early morning. You will destroy your own employer's property.
Not
You will
not
break the
just,
CCTV.
for,
You are
right
a
direction
constable,
I
is not it?
He is a constable.
You are a
driver.
police constable,
driver,
SB driver.
driver, Lordship.
You will middle of the night break the official properties. Better you get treatment in the jail. There is a direction by this court on 1711 that proper care should be taken. Be under the proper care of of the state.
He confessed that in the statement that he usually doing this on the
What is the purpose of doing him? He's stealing petrol or is
stealing diesel from the
vehicles.
and subsequently to it was
That will give you more food, then that will give you more diabetes. So be there inside.
25 liters of diesel was seized from a different person. Where
Everybody said his name. And he even, because the CCTV camera was his obstruction.
he by bamboo to
You dismiss this man. This kind of people should not be.
Lordship, due to medical ground, Lordship, kindly consider.
No,
I
will
may-
not consider.
I take usually.
They may need
insulin.
further investigation. Who are your partners in crime? Isn't it? How many days?
19 days, Lord.
no
19
17 days 18 तारीख आज 22 तारीख
The case diary produced, considering the incriminating material available in the case diary, as well as considering the stage of the investigation. This court is of the view that the further custodial detention may be necessary for the petitioner. Stands rejected. No, at this stage.
May I please the lordship?
Yes.
Lordship 439 application.
Hmm.
FIR lordship starts from page number 11 question 13 lordship.
City.
Yes,
Serious allegations. City.
section. Item number 3 also.
same mail
2 and 3. Isn't it?
Yes.
City, give a date.
so on my lord 11th of December
11th.
May I please?
Yes.
439 application matter.
Huh?
439 application matter.
What is the FIR?
FIR page 12. Where it
How many days?
today is 11 days from the date of arrest.
Considered the material available on record. Full stop. In the considered opinion of this court, the nature of acquisition and the period of detention, do not warrant further detention of the petitioner for further investigation. Accordingly, allowed to the satisfaction of
Is it? I mean,
CCM,
public.
25,000.
Yeah, it's good.
Yes.
My Lord, 439 application, my Lord. Today is 51 days, my Lord.
CD.
My Lord, one who accused has granted bail. My
on
Lord,
30/11
case 24.
That has been granted after perusal of the case diary.
My Lord, today is 61 days. 60 days is mandatory bail. And section involved 420, my Lord. My Lord, kindly see the FIR, my Lord, at page 11.
29/11 only.
And incident took place, my Lord, on
29/11.
My Lord, my Lord,
Difficult. You have made the people's life hell.
already. My Lord, kindly see the nature.
The old man. We have seen that.
nature of
You want a
offense,
rejection. That these are the materials and
already-
your detention may be necessary in other cases also.
my Lord, already
Let us give them handle to them.
one accused person is granted bail. And he on my Lord, he was granted bail on 10/11, my. And today is 22 days. 51 days behind the bar. My Lord, Kindly see the, my lord, wording.
We have seen everything.
Yes, these are serious
Lord,
offenses,
it-
my lord.
We have seen everything,
My
and
lord, that was track of my lord in the ATM. And that transaction, my lord, was conducted, the transaction was made in, my lord, Seniorly, Adabari Seniorly. And they were came, my lord, that was occurred on 24/9.
that is we want to know from the case
Yes.
diary.
Not 25th,
25th. Let us see on 25th.
from Taluk.
Holiday. 25th is a holiday. 28th.
26th.
Kothakor. See on Friday it's possible.
Yes,
We'll
sir.
see. On Friday, give a date.
Obliged.
And you also, you do not file charge sheet in all these things.
May it
They have
please-
made
May it
people.
please your lordship. Lordship,
Yes.
gambling only 520 recovered from the lordship. Jai Thandi Munda lordship.
Item number?
53 lordship. 10 days in jail custody lordship. FIR on page 20. Lordship. Considering the length of detention on the day of Kali Puja lordship night. Lordship.
Considering the period of detention and nature of acquisition. To the satisfaction of
CGM Kamrup Metro. Lordship.
CGM company.
Highly applied.
Agar line.
Highly applied. Okay, application of 439. Fire is a fake. One is the allegation of one of 5 carrying out mutation
How many days?
at this port, 18 days.
18 days is a Mondal, my lord.
Mondal, you are demanding money. Where is the offenses registered?
Vigilance,
No, no.
vigilance
What,
and anti-corruption.
uh,
And
what are the offenses registered? PCX.
7 AFP,
7 up to PCX. And my lord, there is a, my lord, conversation recorded, my lord.
CD. Give when?
My lord.
2020 resorted. Short.
Oh,
4th of December. Better to be there for some time. Then it's easier.
But the investigation is over, my lord, because they are relying.
We'll see that. We'll
they
see
are- they are
that.
relying on a trap witness, man. Trap witness.
We'll see that. Yes.
My lord, this is like child marriage case, lordship. FIR is at phase 9, my lord. Parents of my lord, both sides were also arrested, my lord. They have been granted bail, lord, by Tanagapur without TT lordship. Now, phase 9 is the, my lord. Allegation.
HG2 issue. Neither been lost by the husband. It is further seen that who is he?
My lord is Panchayat secretary, lordship.
The FIR has been lost with the Panchayat Secretary. Yeah? Interim. 10 days. Yes.
All right.
Manipur, 18th of December.
CD interim.
20 December, 2012.
10 days.
Applicant lordship. 438 applicant.
CD.
Intimate protection. I am appearing for accused number 2.
Who is accused number 2?
Accused number 2, Mojibur Rahman Mukti.
Huh?
Accused number 2, Mojibur Rahman. In this case, two vehicles were taken by accused number 1. Subsequently, it was recovered. FIR is page number 49.
What is the allegation against accused number 2?
He was suspected by. But two vehicles were, the brief fact of the case, two vehicles were taken by accused number 1 on the basis of on-take car leasing agreement. My lord, one vehicle was recovered from Hojai police station.
Oh, we know that. In the what circumstances, in what manner that has been
Yes,
recovered, we know that.
accused number 2 and 3 are also involved. They are here, my lord, page 16. Here is the residence of the accused number there. 2 and 3 did not give any specific information about the location of the vehicle because on the basis of GPS tracker, my lord, the concerned person.
I've seen that. CD.
On 30/11.
No. Yes,
My lord, actually, the victim is the sister-in-law of the victim. There is some paragraph, if you look at paragraph 6 from my petition. Some dispute,
CD.
but only it's a sister-in-law.
That
What?
is the difficulty.
This
You
is-
cannot force even your sister-in-law. That is the law.
412.
You can do with consent, but you cannot force. Yes,
Along with injury
yes, injury.
for the second.
CD.
Regarding 2 and 3, my lord.
Who are two and
My
three?
lord, 2, my lord, is my wife of petition number 1. And she is, my lord, another woman, my lord, guardian of another student. They did not have any role.
2 and 3.
Headmaster, my lord.
One will not give. 2 and 3.
Apply.
Interim.
Apply.
On 12.
Yes.
1.7.
1.75 ganja. CD.
14.
CD interim.
I'm deeply obliged.
10 days.
On 21.
The allegation is Milord that the Selby dated 7/2/1992 was Milord forced.
Who are you?
Milord, I am alleged to be his associate, Milord. On the day of the offense, Milord, I will be 12 years of age. I am 43 of age at this stage. On the day,
Who are you?
I am alleged to be one of the associate of Rajesh Kumar Roy, in whose name the land was transferred. I am not the principal accused in the matter.
It is case that will be recorded, man.
And this question is required, Milord, but 92, Milord, my age is 43 today, Milord. So I would be, Milord, at this time,
Where is your age? Is anything on age?
Milord, I have make it page paragraph 10, Milord. I
No,
will take
forget about paragraph 10. Any
Not-
school certificate, anything.
item number. That's it. That it could not annex, Milord. We can produce it to Milord. Our plan,
You produce it too. We'll see that. Then only, otherwise not.
Yes.
Milord.
Anything you can show,
Milord, we will Aadhaar card create, Milord. Aadhaar card and
you
PAN
show us. Then if we relate back to that age of 12,
Sure.
then considering that only will protect, not
yes.
otherwise.
card. I'm okay.
Put it.
Item number? Yes. NDPS,
And yes.
CD.
Not suspected to be not recovered.
Understand. How can it be recovered? You fled away.
He was not there.
We'll see that from the CD.
15.
Yes, so Bothakur obtain instruction
Yes.
whether any case is registered by
Boroy Mari.
Huh?
Yes.
Boroy Mari, please.
Doloimari.
Boroy Mari.
কালি এটা order দিছিলো এস ডট চাই লবা যাতে only it will be on Doloimari police station
Boroy Mari, not Boroy Mari.
Goroimari এস ডট when Bothakur
28/11.
20. Yes,
Page 18, man.
yes.
You lost me.
Bothakur, you are in a difficult position in this case.
Yes.
Whole case is of a Vittilnath of
Vittil-
foreign origin.
Foreigner.
It's neither not a whisper even that it is stolen. So you have no jurisdiction. FIR is liable to be cost. City interim. Applied. Within 10 days.
22/12.
Only appear before the
22.
police.
Yes, yes.
22/12.
My please, your lordship, it's a child marriage case, your lordship. Victim is over 16 years, Your Lordship, on BTP secretary log the FIR. Your Lordship.
Okay, child marriage interim. Within 10 days,
My lord, Vilasipara, 13.
13th December.
Attempt to regular purpose.
CD,
Yes, it is.
Oblige.
So, 8th of December.
8th of December.
Notice.
Notice to go.
Notice to the correspondent number 2.
May I take Your Lordship?
Permission to
consent
Dusty. Permission to Dusty. And to file affidavit, DG2D. Yes. Mahajan's second application, CD. When?
Next week,
Next week, is it
No.
possible? From which place?
Demo.
if my lord, assistant teacher is not been able to.
He should not be.
No, my lord, 7th, my lord.
Huh?
7 years old.
7.
Kindly, my lord.
7th.
It's not.
May not be possible. We have only this week. Try on 30th.
My lord, 13.
Obliged. My lord.
Hey, motion, nothing, second. 30? 7?
17, my lord. In this case, my lord, earlier, the order of this honorable court, regarding instruction, my lord, whether the money is required for the, my lord, this is regarding,
Ah,
yes, my lord, I have received a report from the IO,
Hmm.
and regarding that, my lord, sale deed, my lord, which is, my lord, annexed with the petition, my lord, that is, my lord, notarized. Report, your lordship, my last portion of the report earlier in this case. One difficulty is that, my lord, in this case earlier, my lord, land the Prevention of Money Laundering Act
is
2000
there.
is there. But, my lord, here last portion of the report, your lordship, may kindly handwritten report, my lord. And in this petition also, my lord, petitioner has stated that on 20 IO has later on made a prayer before the, my lord, learned trial court for erasing that provision of the, my lord, Money Laundering Act. And by order dated 21/12/22, as per the petition, and IO in his written, my lord, note also stated that that part was already removed. But from the case diary, I have not found that order of the, my lord, learned trial court. My and petitioner has also not annexed that order. Although mentioned that provision of the, my lord, Money Laundering Act was already.
What is the case allegation?
My lord. On the offer the date, my lord.
Where is the affair?
Date number, my lord.
Case
Case
number.
number 33. Yeah, check number 420 and 413, my lord. Not applicable, my lord. This is simple case, my lord. The money was seized by the police person from my place, my position, my lord. Even Prevention of Money Laundering Act, my lord, that already deleted, my lord. Today, my lord, 11 months period from the date of FIR.
How can money be directed to be released like this? 19 lakhs.
Yes.
You cannot carry more than 3 lakhs or something.
Neither black money or money stolen.
No, black money or stolen money, forget about that. You cannot carry it now as per new income tax act. You cannot carry that much of tax. So until and unless you get a clearance from the tax, how can we direct that, give the money?
My lord, due to
Had
make,
it been a bank or something like that, it is different.
my lord, to make payment, my lord, the landowner, that is, my lord,
Can you make a payment cash 19 lakhs?
my lord,
Is it permissible under law?
that demanded by the my lord, landlord, my lord, it is allowed.
Maybe
That
you will
is
have
the
to
prudent.
disclose the source. How can you have a 19 lakhs case?
Yes,
And
my lord,
exact-
Either you have to withdraw
Yes,
from the bank
yes.
or you will have to disclose the source.
yes,
And
my
We
lord,
cannot direct this like that.
my lord, for this process, I have told my lord, full Punjab truck body, my lord, that, my lord,
Can you sell a Punjab truck body by cash?
actually, my lord, I have this,
That
my
is
lord,
the problem.
Yes,
Can
and my
we
lord,
allow
those
to,
land documents they have
until
not
and
produced
unless
before.
income requirements clearance is there,
Yes, ma'am.
otherwise you can, you spend this cash, how will income tax will department will hand over?
my lord, he is a by profession, my lord, grocery shop, my lord, having a trade license and, my lord, GST also, my lord.
Why are you not understanding, Mr. Counsel? I am having known source of salary. Okay. Even from that salary, suppose I keep it in the account, I cannot withdraw tax and cash amount beyond one limit. You may have source of income, but you cannot have cash transaction. That is not permissible. So therefore, they have doubted it that how can cash be? It may send you to the Bangladesh. We do not know. That is the allegation.
My lord, the tenant to the it is the nearby that place.
And my lord,
That is
now
he
in
went
this
to the-
petition, my lord, they have annexed, my lord, land sale document, but they have not produced this document before the trial court while, my lord, entertaining that Rima petition.
The
my lord.
releasing of cash is difficult until and unless you are the recognized financial organization. If you are a bank, your money is seized. You have allowed a trunk load of cash to be released to the bank because it will be circulated through the bank.
Yes.
What will you do with the 19 lakhs cash? We cannot give a permission to have an illegal possession. What do you say? Satisfy us that you can have this amount of cash, you can carry this amount of cash as
Yes.
per this.
Yes, my lord, I agreed, my lord. That is the my lord, wrong, my lord. From the side of
If
the
it is
prisoner,
wrong,
my
it
lord.
is wrong,
Yeah, my lord.
criminal. Can we?
My lord, on the request of the landlord, my lord, he went to the house of the landlord, my lord.
No, you'll have to
saying-
disclose the income tax. From where have you got that land?
Nearby
Money?
that police station, my lord, where that is the money, my lord. Nearby that police station, my lord, just crossing the police.
Oh my goodness, that these are not the issues before the court. Can we take in a 482 petition all this ground or consideration? No, he was a neighbor to the police station, so he can have a cash of 19 lakhs. He has a land, so he has sold it, so he can have a cash of 19 lakhs. So give it, it's a legal money. Give it to him. Can we say that? If we can say, so us. If we can say, we'll say it. We are guided by law. Tell us. So are some provisions of law that yes, by virtue of this provision, in case of a land sale or agricultural land sale, an agriculturist can have a 19 lakh cash in his hand. On the prayer of the learned counsel for the petitioner, the matter stands adjourned. Mr. Bothakur, learned additional public prosecutor, has produced a report in terms of this court order dated, or in terms of this court's order dated 18/11/2023. Same be kept with Mr. Bothakur. Same is returned to Mr. Bothakur and we produce on the next date. Yes. List after 2 weeks. It's not a possible thing. Cash cannot be released.
And the section also my difficult, my lord, not applicable, my lord. In this case, my lord, section is typical, my lord. 420 or 413, my lord, not applicable, my lord, in this case. That is also, my lord.
Come for quashing, we'll see that. That can be a very good ground for quashing.
Yes.
Then we can give you very relief that yes, that relief, it is not our lookout whether it will income tax or whoever. If income tax will be at liberty to take action against you, we can observe that. If no case is made out, file a
That
quashing.
was a deleted by the Tarnet court, man. The money, payments of money is there. That is the problem, man.
You keep that money that has been deleted, file a quashing petition of the affair with the all that this is PMLA is not applicable. 420, 406 is not applicable. We'll see the material CD collect what materials collected in the CD. If possible, we'll quash it. If you you can make out the case. If we quash the entire proceeding, we'll direct that return him back the money and with a liberty to the income tax department to proceed in accordance with law.
Well, then my lord, possible my lord, the passport of my lord, I place my lord,
This court is of the view that in absence of any determination as regards the illegal case, whether it is legal or not legal, this court cannot entertain a Jimma petition. Accordingly, the same stands dismissed.
with regard to
I am giving you an adjournment. If you do not understand, I dismiss it. Yes.
Up 2 weeks, my
After this.
No, I may be allowed to return back the case.
Mr. Thakur is allowed to return back the case. We'll see. Because before the case diary, we'll have to see whether this is, we can give a direction to release a cash amount of 19 lakhs to the petitioner. What is the guarantee that he will not use this? We are giving an illegal direction. If no cases matter, there is a different. Yes.
Yeah, please.
Yes. What is this?
Passport of my lord. Regarding my lord, commercial quantity, my lord, teacher, and
We'll take it
This-
after all methods are over. Have you gone through it?
yes,
Just mark it.
yes, I have.
Huh?
But this time I have my lord,
Uh.
decided to yes, lord.
It is submitted that charge sheet has already been filed by the investigating authority after completion of the investigation. Being charge sheet number
217/23 dated 309/23.
309/2023. Full stop. In that view of the method, the present bail application stands closed with a liberty to the petitioner to approach the learned court below, learned trial court,
Right.
learned trial court by filing regular bail application. Full stop. In the event that the application is filed, dispose of. Yes.
Senior counsel is out and fix it on 28.
Here also LCR is available.
This is NDPS.
No, my lord.
EAP.
We'll take in the next year.
20.
28 is not possible, not at all possible.
Another matter is on that. Related.
Out of the same
Yes.
same offense.
Yes.
Okay, it is submitted that connected bail application being BA number
No, my lord.
criminal. This is okay. Criminal petition is something different. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed. Give a date in December. 19th of December.
My lord.
Oh, LCR has not come.
Yes, there is.
LCR is available.
Available, go through it. Just mark it so that on the next date we can decide. 19th of December.
Okay.
What is this?
Poxo matter 69 days. Is 70 reported.
So what to do? That's it being
Case number मतलब 373 dated 30/10/20.
approach that trial court.
The second date application.
Where is the earlier order?
It is not available.
But the TT was not called already.
Okay.
The first step
Oh, yeah.
should have been in the motion column. The earlier order is at page 29.
Oh, before-
Call for the case date.
He is already 75 days.
He is in.
75 days.
It is 302.
30
We can recall the thing, how you have beaten them up in the head.
Yes, yes, sir.
Isn't it?
That lordship has reflected in the order.
Order also. Where is that order?
That is at page 20.
See, looking at the affair, I can recall what was in the city. Where is that?
At page 29.
17.
Johiruddin Ainuddin
Right.
inflicted injury on the head of Mohiruddin with bamboo stick,
Okay.
who subsequently succumbed to such injury.
There was
75 days.
a fight between both the fire.
We understand. But ultimately,
Cross FIR also was
302.
there. Our side also is suffered.
That we understand. 75 days. It is 90 days. Do one thing.
Whether success file or not, my lord.
That you have the instruction.
What is
This-
time, my lord? Maybe we can for pass. No, if that instruction only on 29, my lord.
29th.
Ah.
29th.
Twenty-six and 27 in respect of the same petitioner located.
Ah.
Two case now, different police station. In 20, item number 26, he was thrown arrested. He is in custody for last 47 days. Some baseband unit of Airtel was stolen.
Oh, you are the
Yes.
employees.
Yes. Well,
You have two employees.
Yes,
Tezpur.
yes.
Well, as per my instruction, item number 26, search sheet not yet submitted.
Ah.
But regarding item number 26, 27, search sheet submitted.
So 26, considering the period of detention,
In 56.
considering the length of detention
47 days.
and the stage of investigation. Allowed. And what about item number?
27, search sheet submitted.
Search sheet submitted being
Case number 204/23, dated 20/10/23.
okay. 23, 20. You appear before you file an application.
He cannot appear. I am in custody.
Sorry, you file an application. Disposed of.
Item number 26 will be CGM Kamrup Metro.
CGM Kamrup Metro.
Wait, period. Okay. 439 application, my lord. It is a charge sheeted case, my lord. The petitioner was arrested on 12/3/23.
You have gone through it?
Yes, my lord. Now, my lord, it's a very preliminary stage. It's a stage of my lord, a copy, my lord.
Okay, we'll take after some time. Will this pay these matters which require some application of mine?
In that case, my lord, although he has submitted, my lord,
No, we'll take after
No,
some
no,
time.
I'll make an adjournment, my lord. That's why, my lord.
Because
I'll take an adjournment. That's why.
Okay, okay.
But only one point, my lord, that is to be clear. But charges have been paid.
that's been
Charge frame.
Okay.
Charge frame. But the problem is, my lord, that the court below, in the court, my lord, said that we have framed the charge. He has taken the file to his chamber, my lord. No next date has been given.
We'll see because something has come.
Yes, then, my lord, after some time, my lord, in that case, my lord,
Which was that order? Order dated?
order is not there, my lord.
No,
We
no.
have
When charges were framed?
Lordship may seat order dated 27/10/20.
27, 10.
20. The trial court has fixed the case for framing of charges on
On-
10/11/23.
Then what happened on 10
On
till?
10/11/23, charges were framed and the records were taken to December, my lord. Till date, no next date has been given.
Okay. We'll take up today or some other day. We'll have a.
Some other day.
You go through it. We'll obtain.
Because
You can have the
Certificate copy.
not certificate copy. In the CIS system, you can see the status of this case.
Just now we have checked, my lord. It is not up to date, my lord.
You take a screenshot or something of that. Give it to us.
10/11, my lord. 10/11, it is for cap for my lord. For consideration of charge.
10/11 charge frame.
And then, my lord, after that, there is
That is submitting, my lord, as a counsel in the bar, my lord, with all respect. but
No, that I understand.
I do not.
You
lie, my
said
lord.
that 10/11/2023 that was fixed.
Ah.
According to you, SARS has been framed on
Framed.
10/11.
Yes.
So you have that order from downloaded copy. We do not need certificate copy. You can
Right.
have it.
Right.
And that screenshot that thereafter noted.
Yes.
Okay.
Yes.
That cannot be.
That can-
That cannot be. We'll take after some time or today after tomorrow.
Day after
Tuesday.
Tuesday.
Tuesday. Please, this the scan copies has been received. Mr. Goswami shall go through the same and assist this court. Full stop. The registry shall also obtain
update status.
obtain a status of the case proceeding pursuant to order dated
10/11.
pursuant to 27/10/2023, in as much as the orders, the scan copies of the orders are available till 27/10/2023, and next date of matter was fixed on 10/11/2023. And the mail addressed by the additional district judge Karimganj to the register of this court reflects that same was sent on November 21st, 2023. 2020. Today is
November
22nd. It has reached yesterday, 21st of November 2023. However, no order sheet has been furnished subsequent to 27/10/2023. Full stop. If necessary, registry shall obtain the or subsequent orders through the CIS. List this matter on.
I have one on merit, my lord. Here, my lord, nothing has been seized from. Only one phone. CPF.
And from whose position that has been?
It was seized from a vehicle where the driver and two persons were there.
How are related to the vehicle?
No way, man. I am a vegetable vendor. Man.
You may be a consumer.
I am a vegetable.
We'll see that. We'll see that. You go through it.
I'll-
Yes.
on that.
I am obliged.
Hmm.
Okay,
You want an adjournment?
No, your lordship, it may be possible for the typing.
Time being. Yes, sir. What is the status?
Is there
Is the receive? What is the allegation?
application, my lord? He is an executive engineer,
Hmm.
practitioner,
Hmm.
and he is on interim also.
Hmm.
And, my lord,
What is the affair?
accident took place. One accident took place.
Hmm.
In the at 1 a.m.
Hmm.
A person, my lord, met with an accident, and it is alleged that there was negligence on his part, on the part of the department, and being, my lord, executive engineer of that construction part. But there was
What
no
are the offenses?
offenses. 304 is there, my lord, and 51, 52 of the damage management.
The case diary.
I pray that the
We are rejecting your bail application. Case diary produce is perused. Full stop. Considering the nature of acquisition and material available on record, this court is of the view that no custodial detention of the
One thing maybe.
yes petitioner shall be.
Otherwise, he appeared,
Ah.
but his statements are not there. And, my lord, subsequently, the IO tried to interrogate him.
Okay,
Now
we
he
will
is sitting-
protect him. He might be busy in national highway.
he is,
Ah, ঠিক হলো? Of the view that no custodial interrogation is shall be necessary. Full stop. However, the case diary shows that the statement of the petitioner has not yet been recorded, as well as the IO could not find him out to record his statement.
Yes.
In that view of the matter, the petitioner, in that view of the matter,
whenever he is called, well, he says, well, yes, I am coming, but he doesn't.
he out of here is not
if I
coming.
may submit, your lordship,
Just wait. People, we are dismissing a petition. Yes. In that view of the matter, in the totality of the matter, comma. Itu colon hai? Okay. In the totality of the matter, the present bail application stands allowed with the following terms and conditions. You will appear within 10 days before the IO. If not, it is liable to be cancelled. Within 10 days, record his statement.
My secretary maybe record.
Your senior is not here. We are on live streaming. How can we record your senior's name?
Your name will be recorded.
Your name will be recorded. Give your name. Your name?
It is second.
Yes, yes, I can. Yes, there will be returned back.
29.
I have interim law.
Yes.
29, I'm sorry, my lord, case diary is not received.
Yes, there is not received. List on.
Interim, sir. First week of December.
First week of December.
Uh,
Not give a date.
on-
Give a date.
on- yes,
Otherwise,
yes,
it may be
Sorry,
possible.
8 of
8th of December. Interim to continue.
30, my lord, charge sheet has been submitted.
Charge sheet being
Charge sheet being number 102, dated 15/7/23.
interim order to
Under
continue
section-
G2D.
Under section 341, 323, 354.
Under 341,
341, 323,
Hmm.
354 IPC.
354 IPC. Dispose of.
So my lord,
She did not receive.
charge sheet submitted, my lord.
Charge sheet submitted. Huh? Being charge sheet number
55/23, dated 31/8/2023.
full stop. Okay, not necessary. Other section. Okay,
No.
further. Interim to continue. G2D till he appears. On earlier addition.
Your lordship, my
Hmm.
senior is on the way at park.
Your scene is on
the-
on the
Wait.
on the legs. Okay.
Yes, receiver.
Yes,
Lordship, I am on interim.
Yes.
He was called for on the
it is received.
city not received, my lord.
When?
My lord, 22nd of December.
22nd. Interim
Yep.
to continue.
Yep.
Yes.
So 438 application.
Mm.
I am in interim. Lord, his statement has been recorded.
It is there. Huh?
Statement recorded.
Considering the nature of acquisition and materials available of record. In our considered opinion of this court, no custodial detention of the petitioner shall be required inasmuch as the petitioner has cooperated with the investigating officer and got his statement record.
Oblige.
You are on lake, lordship.
Why you need your senior? Will it make any difference?
Oh,
Except recording his name? What is this?
Lordship, on FIR is page 15, all key petitioners are the Mondal trainee, lordship. In
So
2018,
from the on the training itself, we have started
no, lordship.
performance.
Allegation is that before
You
training,
have started performance during training itself.
the one, lordship,
Very good.
they have been recommended by Secretary, the North Pata his autonomous council, and thereafter the revenue secretary, lordship. And some unsatisfied candidates who could not get the seat, they have filed a complaint that our residential certificate is fake, lordship.
My lord, here
We have, lordship, appeared before the IO, lordship, after interim.
applicant city will be required because the city is not up there regarding
Okay.
their
The
statement.
learned additional public prosecutor submits that an up-to-date case diary shall be required inasmuch as the statement of the petitioner are not available on record. The statement of the petitioners which are stated to have been recorded pursuant to of this court's order dated, which was the interim order? pursuant to this court's interim order dated
29/9.
29/9/2023.
29/9/2023 is not available. Full stop. Accordingly, the matter stands adjourned. Full stop. The case diary be returned back to the concerned IO. Full stop. In the meantime, the petitioner shall once again appear before the IO within a period of 10 days.
12
Interim order passed earlier shall continue. Please this matter on
12 December.
12 December 2023. Till then, our interim order passed earlier shall continue.
I have any employees of it.
Charges submitted.
Sir, sheet submitted. What is this early page annexure 23?
My lord, that was rejected by your office. Case 23. Subsequently, your office has
Granted interim.
granted interim lawsuit.
On what ground you have granted
My
interim?
lord, in fact, this is the counter class case of the government.
Okay, interim is made absolute. Yeah, definitely good. Till he receives someone from the it's a sessions tribal. It is a sessions tribal
My lord,
by the trial court.
okay.
And files an appeal.
Charges number 437 of the 23. Dated 27/10.
Yes, you wanted an adjournment. Yes, case
Yes.
there is a
Final report submitted by part.
that is. That's why we did not. It is submitted that after completion of investigation, the investigating officer has filed closure report being
535 dated
being
27.
under being FF number
FR number
FR number
535 dated 27/10/20.
23. In the view of this matter, nothing survives in this petition. So accordingly, same stands closed.
May I please report the date application on the considered copy at page 11. Page 11, my lord.
What about respondent? Because some steps are it is a POXO.
I am very
You are appearing for the respondent. Where is the FR?
FIR page 11, my lord.
Second. No, it is second.
This is not a case for interim.
Yes, my lord, here from the case that there are sufficient incriminating
This is
material.
not a case. Where is the police? Have you arrested the police?
My lord, regarding the Jayanta Kumar.
What about this Joyanton or something like that?
He along with my lord, he is the BDP secretary along with Jayanta Kumar Das. He is running a syndicate.
Syndicate? No,
collecting,
this is
my lord,
not a
10
case.
to 20,000 from the villagers.
Petitioner being a lawsuit, a PTV secretary. Whatever the police can.
You should be arrested forthwith.
My lord, he only just identified the identity of the person where notice was given.
Yes, give us the case. That let us reject it by a reasoned order.
Yes, my lord. I have trademark from my lord.
PTV secretary, BP the secretary identity.
Arrest him immediately.
Yes.
This is not your job.
That was not lawsuit. Both of the that was done.
Statement of my lord, those villagers also available in the collecting 10 to 20,000 from the
Somebody has been arrested, isn't it?
Yes, what the person?
Jayanta,
And
rightly arrested.
he's a police personnel
Ah.
of border branch, Morigao.
What is your name?
Really. He's VDP secretary.
Hard. The learned counsel for a petitioner also is very productive in a petition certificate. It's a productive. From the case diary, it is seen that from the case diary, this court has found sufficient material to suggest the that the petitioner, along with the arrested petitioner, namely Jayanta Kumar Das, a police official from border branch, Morigao Police Station, Assam, has been demanding money and accepting gratification of some of the villagers of Thangara, Morigao, Assam, by putting the victims in fear that the court has declared them, that the foreigners tribunal had declared them as Bangladeshi nationals, and such case can be settled if amount of money ranging from 10,000 to 30,000 are paid to the said police officer, said the police official. First of all, considering the material available on record and for further investigation, this court is of the opinion that the custodial detention of the petitioner may be necessary. Accordingly, the bail petition stands rejected. Interim order stands vacated. Case diary is returned. Yes, Pothakur.
42, my case diary not received.
Case diary not received. When?
He's on interim. 11-12.
11-12. Interim to continue. Yes.
The petitioners are detained. After that, interim being granted to take it to the IU and got their requirement recorded. Your material ought to be funded.
Yes.
But otherwise, they appeared. Statements were recorded. If there are some land dispute, whole land dispute going on
But
between them.
what was the injury and all?
The injury report is not here, and there is one note that after getting interim, they are trying to influence police. But injury report I have not found.
But because there is a, is it a fact that they have forcefully entered into the house?
Yes, from their
Is
statement.
there any?
Their statement is that they entered the house.
And that this dao and all has been used, and their houses are thrown away.
Yes, in their
They have
statement,
been-
they are saying they have not beaten up anyone, but they have broke the house because that the victim Their statement is that their victim, they were staying in their property in class 4.
No, do you understand? But
Yes.
what are the offenses registered?
So there are several sections are
Under
there.
section 120P, my lord, 143, 147, 148, 54P, 323, 379, 427, and 50.
Which are bailable, which are not bailable?
Only available, non-available sections are that, my lord, section 354P and 330. Other.
There are photographs shows.
So
We have also admitted that we have broken the house. We also
how
admitted
can you do that?
because I have made a statement in paragraph 5. So they forcefully directed the house following a certain minute. There is a case pending, still pending. Before the learned civil judge senior division.
Who filed this case?
Milord, the accused number 1 filed the case, not against the present informant.
For
Milord, eviction of the informant and other. Your lot will. I have also annexed it. Annexure 2, page number 9, page number 19.
any injunction in that case?
Milord, so far as the I have not collected the order, Milord, but so far as the case history in the report shows, Milord, that there is a step.
Who filed the suit?
The present petition number 1.
Filed the suit. And there was a direction for
Milord, step.
stay. What stay?
Milord, because that they have already erected the house. Milord, status quo has been given that there is no further construction or further work.
Okay. So if there is a status quo, how can you break it?
Milord, prior to Milord, when they entered into it, prior to that we have Milord approved the right.
Then there is a status quo.
Milord.
Now we do not know whether you have constructed after getting the status quo to prove that I am in status or he has done it.
And moreover, Milord, another aspect is also that, Milord, this 1992, Milord, litigations are between the parties. I have also annexed, Milord, several
one.
I have also annexed, Milord, the
That black mark. The report.
annexed 3, 4, 5 also with regard to civil disputes between the same party.
You are the land brokers kind of a people. Yes, why don't you? What is the meaning of FR? 506 will grant him bail. Bailable offense.
Yeah.
What are the offenses tell us registered? And what are the offenses not bailable? What is a 354B? What are the materials that has been stolen? No, we'll consider. Please answer the first two questions. What are the things that have been stolen? Hmm. This is not a way to take. You could have filed an application, land grabbing, everything. Police is helpless. Police cannot register land grabbing cases under FIR. And they are apprehending, and you are people of very bad character.
No, my lord.
You have even threatened it.
No, my lord. Subject to your notice.
Police is helpless before you.
No, my lord. How? Because when I have
Police is helpless. That only that ground will reject your petition,
no, my lord.
so
Kindly
that you
consider
remain
my
under control.
subject to your notice petition. Even since 1992, my lord, between the same parties, my lord, the suits are going on continuously. Even I have my lord,
We understand
pre-order,
everything.
my lord.
Disputes are going on. Cases are filed. Very nice. Who filed the suit? You.
Petition number 1.
When filed?
It was fine, my lord. I have appendix 3, lord.
But material shows that they have been living there for since long back.
If I am not wrong, my lord, it says, my lord, 40 years back, they sold the property, but out of, because these people are very a simple person, they didn't collect the document. Now taking advantage of that thing.
Who is possessing?
Now victim is possessed. They are settled there.
Who sold to whom?
But the petitioners, their fathers,
Sold this land to these people. And now they have taken back the land documents and even original land documents.
They didn't hand over the land document, taking advantage because those are simple persons.
Who is simple is difficult.
Yes.
Let you fight in the civil forum.
Basically,
Mondal, fight in the civil forum. This is not a 40 years old house. I'll tell you, because we have also some experience of doing civil cases. I'll tell you the story. You are possessing the land. Two stories. You are possessing the land. He filed a suit, he got a status quo. So status quo is the most dangerous thing. Moment status quo is given, who is having force, he will maintain the status. Either they have thrown you away. This is one aspect. Or after getting status quo, you thought that now it will remain vacant, let us enter. So with that, this we cannot decide. You fight in the civil court. No. FIR is fine, but where are the independent villagers that they are in possession? Except the police.
That particular photograph, those are basically temporary.
Temporary, say. This is not a old kind of 40 years house. This is number one. Number two is there is no villager statement. You get it updated. Okay, the learned counsel for the learned additional public prosecutor submits that he may be allowed to have an updated case that prayer is allowed. List.
Even the my lord.
List.
My lord, on
21st December 2023. Interim order passed earlier.
May I submit one?
So and so Mondal is for the information portal. Okay. Yes.
44
City not received any interim.
No, my lord. Interim is required, my lord. Not dependent.
Why interim is required? Interim you have not.
Page 9, my lord.
Could not satisfy the court. How can you grant it now?
City FIR, my lord. I am not named, my lord. Some blanket. Now winter season come, my lord. Village vendors, my lord, purchase some, my lord, blanket for sale. Some other rebel parties filed complaint. police sees the blanket. Now police has filed FIR, my lord, under section 379 and 411. Blanket was seized from godown. They counted without any record.
Who are you? Who are you?
My lord, Dilwar Hussain, I am not named in the FIR also.
What
Nothing
is
has
this
been,
FIR? Who lost this
police
FIR?
file FIR, my lord.
No other business or what? Police? Huh? Where necessary, they will not file charge sheet. And where unnecessary, they will do all this. Case, application suspension. Case diary called for is not received. Considering the nature of acquisition, nature of acquisition against the present petitioner. Considering the nature of acquisition and the fact that petitioner is not named in the FIR interim appear
Apply.
might be at the behest of some big dealers.
Date January details. Interim. One application. But if here in this case, the last application for directed to the respondent number 2 dot for the appearance. It is 70 and 4 October.
What is her age?
Age was 17 years 2 months more. Except for I think not applicable for just as per the those two factor 4, the age below 16 notice, the problem is notice the 17 years 2 months more. Also, not such a fine.
Why Pokso is not? Huh?
It is 17 years. It's below 16. Suppose 40 and
My daughter is 18 years old. Philip, fact is that, my lord, that both boys and boys,
Hmm?
the boys.
We understand, but until and unless scan copy is there, it speaks for her evidence.
Not to say that
No. Pokso staying is a difficult proposition, more particularly in terms of order 26th and 2023 on the next date, because it says that it will be after receipt. So that is why. Already a judicial order is there.
the order.
You keep it, you show it personally. Okay. 58. Yes.
Criminal appeal.
First time. Means second time. This is an appeal under where is your appeal memo? See this. This present appeal is preferred against present The present appeal is preferred under section 374 bracketed 2 of the Code of Criminal Procedure 1973 against the judgment and order dated 16/10/2023. See at display. Perfect. Suspense. Admit. Call for the record. Issue notice. Steps within 5 days, both ways. IA. Write it in IA. This is an application under section 389 of the Code of Criminal Procedure. See the page, suspension of sentence of the impugned judgment and order. Repeat that, comma, considering the period of detention, considering the period of sentence as well as material available on record. This court is of the view that the petitioner should be. This court is of the view that the sentence passed in connection with the aforesaid judgment is required to be stated according order accordingly. IA stands this for the petitioner. Are you in previous bill?
Yes.
And the petitioner be allowed to remain on previous bill. Ordered accordingly. 6 weeks. That is required to be suspended and remain shall be required to be allowed to remain on previous bail till disposal of the appeal. Okay, ordered accordingly. Yes. Deposited 50%.
No, not, no, nobody has appeared.
Yes.
We have not received any instruction from the.
Okay.
As if we have informed him, but we don't
Okay.
get any.
This court, the present criminal revision petition is filed assailing file under Spencer 482 Code of Criminal Procedure for setting aside and quashing judgment and order dated 11/7/2019 passed in criminal appeal number 224/2016 by the Honorable by the Additional District and Session Judge number 1 Kamrup Metro at Guwahati, whereby the judgment and order dated 11/7/2019 passed in criminal appeal number 224/2016. No. Same I have written. No. Whereby the judgment and order dated 13/7/2016. Okay, passed in CR case number 02 of 2013 by JMFC, convicting the petitioner under section 138 of the Negotiable Instrument Act 1881 and sentence 1881 was upheld. Full stop. This court, while admitting this appeal,
I ordered this at 30/10/2019.
for this court under its order dated
30/10/2019.
30/10
Yes, 2019, subject to payment of 50%.
30/10/2019 has admitted issued notice admitted for hearing, admitted the revision petition for hearing, subject to payment of 50% of the compensation amount before the trial court within a period of 6 weeks from 30/10/2019. This matter is pending since then, and on 8/9/2023, this court once again directed on the assurance of the petitioner, this matter was adjourned with on the assurance of the petitioner that he shall deposit the 50% of the compensation amount before the learned trial court below. Full stop. However, when the matter is listed today, learned counsel for the petitioner submits that he has not received any instruction from his client regarding the deposit of the aforesaid money. Full stop. On the other hand, the learned counsel for the respondent submits that no deposit has been made in this regard. In view of the aforesaid, the interim order dated 30/10/2019 stands vacated.
No.
And the the respondent shall be at liberty to proceed in accordance with law.
Leave it. Leave it.
No. Item 13 that
19 is the regarding the healthcare.
that NDPS.
NDPS.
And 19 is
19 is the NDPS.
so we'll take us or we'll take it some other day.
Other.
The petitioner says that 19
So lawsuit just see the PW1 for one.
give me just I'll remember
Because that will
that will help.
PW.
What is the name of this petitioner?
He is Shahjahanuddin. He is one of the accomplices who were arrested. Thereafter, he is also. His contraband was recovered from one Alta. And after the arrest, he is also arrested because of the connection. And the same.
What is his name? You just repeat it.
This one is the main from whom he is one Altaf.
Abdul Fattah and Abdul Salik. Abdul Fattah and Abdul Salik are the brothers.
Yes, they are from.
What is the name of this petitioner?
This petitioner is Shahjahanuddin. His complexity, your lordship, it will reveal from the CT part, the statement recorded.
Okay, which?
His statements, I have reflected in the 161 statements that are
Of the accused.
Accused, these two, Abdul Fattah and others, and also his own statement. How they are operating as a gang.
But now we'll have to, it's just what I'm saying, you'll have to address the after the judgment of Tufan Singh, or I forgot that.
Yes, that is trial stage, but that is there, And now,
no, see, basically when the rigor of 37 is there, we'll have to have a satisfaction that he is not guilty. Okay. From where will you come to that satisfaction? We'll have to come to that satisfaction on the basis of prima facie. That cannot influence the trial. Because there must be a balance. So after Tufan Singh, I think Tufan Singh, the statement is gone.
Yes.
Now, if you come to the, just think over it. I'm not taking any view.
Sir.
If you come to the and statement of this member. She also said that I do not know whether he is related to the other two accused
Yes,
person. When I went to the commons of Abdul Fattah, I found that they were sitting on their courtyard with their hands tied with piece of cloth. Police later brought accused Shahjahan from his house. Okay, anyway, these are.
It is expected because they are only the seizure witness.
Huh.
They're getting interested how
But
they are related.
what are other, because what will be required to convict him? Minimum.
Yes.
That
At
is,
least the connections have to
there
be
must
there.
be some connection.
Yes.
His connection is only his confessional statement or statement of the co-accused. Other. Okay, we'll see that. Okay. Just you show that, because otherwise in general parlance of law,
Yes.
a person cannot be, if there is no other corroborative evidence, a person cannot be convicted
Yes.
on the only on the sole testimony of a co-accused. If that is the applicable law in
Yes.
case of NDPS also,
Yes.
then what
Yes.
can we do?
Yes.
Just you enlighten us on
Yes,
that,
madam. And
because this subject is for me
yes,
also.
my lord. And my lord, so far this petition is concerned, it is only for the bail purpose.
Ah.
And there are decisions which says that, my lord, that on the if it is consideration for bail, my lord, 161 is relevant.
Okay, you bring that.
Lord, that is
Okay,
one
so
judge-
then 161 is believable, because now the statement, confessional
there,
statement,
my lord-
and 161 is having no different footing. It's the same footing.
Same.
That is also not admissible. Now this is not
and-
admissible. If there is judgment who has said that for
Yes.
the purpose of bail,
Bail.
that should not be gone
And
into
in
that.
that
This
case,
is a
yes.
co-accused.
in that case,
Then
Tufan Singh also discussed.
okay, you
Yes.
bring that judgment on.
And my lord, here, my lord, 161 is, my lord, says the statements under 161, it is, my lord, under 67 of
Ah,
the
NDPS.
Act. This is more
More relevant, but section 67 so far relating to in the judgment says that it cannot be relied for conviction.
Yes,
That is there.
conviction.
Not for bail.
Yes.
So you bring that judgment, we'll have it when? As per your convenience.
Lord,
Next week?
Next.
Okay, give a date. Give a date. 30.
So, my lord, the neck of my lord.
I understand,
my lord,
because see, as a judge,
Yes.
our eyes are closed. We'll have to
Okay.
go by the law, isn't it?
Yes.
We cannot take all these
it
decisions.
feels, my lord,
Even if sometimes we understand, but our own understanding will
Yes.
not do. It
And
is the law.
yesterday's case also
We must be guided by law.
so bad. Yesterday's case,
Yes,
my lord.
yes.
It's a, my lord, seizure of 40,000
Okay.
tablets. But
But see, now this time you have done a good job, because you have taken a person.
Yes.
If he
yes, at
becomes hostile, you
Yes.
can take action against
Yes.
their wife. You have done
in
a good.
all the cases, my lord, you see, my lord,
So
they
you
become
must
hostile.
have a reliable witnesses also for
Yes.
such.
Whereas, my lord, some attending parties also there afterwards. Because something that at least that my
But
lord,
see, supposes all became 6 witnesses became hostile. What do you do?
Yes.
Even if we assume that everything is
Yes,
correct,
yes.
then also you
all
cannot.
six, yes.
Yes. Two.
Item number 13.
13 is what? At 2. What is that?
Motion maker. He stated that at that point of time, the accused person is of 12 years of regarding forgery of my lord, cell deed. of
Okay, he
1990.
was supposed to give us a.
But I
Okay.
will point out, my lord, that is not the question here. Forgery of that document of 1992, but that offense was committed, my lord, on the basis of that document. Mutation was done recently, my lord, on 10/11.
Okay. Who is he?
He is, my lord, one of the in FIR, my lord, specific allegation. He stated the accused, my lord, informant stated that, my lord, their father and my lord and his, my lord, died long back in the year 1954, and thereafter, my lord,
Cell deed was done. Mutation was subsequent. So he might be involved in mutation also.
Yes,
That will be revealed from the case there.
yes.
Then at that point of time, what was your age?
Well, that time I was major miller, but the allegation is with regards to the cell deed dated 92.
Who is the beneficiary of the cell deed?
Rajesh Kumar Roy, I am not the beneficiary.
Now, why are you apprehending them?
Miller, 41 in notice was issued Miller to me.
Go and appear.
No, Miller,
He's
that is
named
the-
in the FIR.
Huh?
I'm named in
His
the FIR,
name in
Miller, and
What is his role attributed?
Miller, associate Miller of Rajesh Kumar. And Lordship can see the notice. Miller.
land is situated where?
ecosystem. And Lordship, my kindly have noticed, my lord, of 41A, my lord, I was defaulted in appearing, my lord. That is the only fault that I have committed. I was asked to appear on 13, my lord, which I could not appear, my lord. On that day, I was out of station. Page 24 is the. So even investigating officer is not wanting to arrest me, my lord, but there was default, that's why I'm appearing, my lord. That has come. Page 24.
I think you are the main person to felicitate. You are local land broker. Huh?
Lordship.
You are local land broker.
Lord, I am a businessman, my lord. Lordship, but Lordship,
What is your business?
Lord, if Lordship finds material, my lord, in the case that Lordship.
What is your business? Tell us.
Lordship.
What is your business? We'll have to disclose it.
Builder, my lord.
City.
Lordship, I have one submission, my lord. To Lordship, is Lordship, remember, my lord, we have mentioned it for the criminal petition, or the criminal petition notice for it. If the Lordship sees the FIR, my lord, and complete, no offense is made out against him. And Lordship, there is a.
Oh, FIR is not encyclopedia.
No, agreed, my lord, but if the Lordship sees the offense.
Well, even if we due to the development of law,
Lord.
even in case of quashing, we go into the city. Therefore,
Yes, Lord,
we do
I
not interfere
agree
at
with
that.
my lord.
That
But-
is why there is no stay in
Lord,
the investigation.
I agree with
You may be, they have called you, go there.
Lordship. My lord, only there is a default. They have called me on 13. I am on 18, my lord. We have filed this.
Why have you not gone on
My lord,
30?
I was out of station, my lord. That was the
Have you
situation.
intimated them?
No, my lord. That
Then
is
why?
for that mistake, my lord. Let me appear, my lord.
Yes, that's what you say.
Let me appear, my lord. That is the
Lord,
only.
so far,
See, apparently from the FIR, his role is not specific. And beneficiary of the sale deed, even if it is posed, is somebody else. Now, how he is related? Whether he has, suppose he unknowingly he may enter into agreement with the person. So let him give a
But
benefit of doubt.
Yes, one thing, my lord. So far, offense under section 420 and 468 is concerned. That occurred in
No, we are not
1992.
going on to that. We are not happy.
No,
That
in 1992, because this is a registered sale deed. Deed was registered in 1992. Now, his claim is that in the year 1992, he was a minor.
So
10 years
we are
later.
even not going to the minor. Because his registered during 1992, there is no requirement of all this online and all. So this used to happen. You will bring anybody and everybody produce with the photo identity card, they will register it. We'll see whether that can be also cancelled in the civil suit. But what is the role of this person?
That is not specific.
Not specific, number one. Number two, let the investigation continue. Let him make what is, because his statement may also help you.
Yes, yes.
If necessary, we'll
that is
reject this. Okay, interim within 10 days.
I'm
City on December 18.
18.
I'm extremely sorry I could not be
No, not an
No, my
issue. We have
lord,
enough time.
No, my lord, the counsel for the other side has said I have been appealing the case for success.
No, I'm not saying that council, everybody.
So I was just laying in court number.
No, today I'm not saying. The record shows that most of this bunch of orders, most of the orders are for adjournment. I'm not saying you or he.
It is, my lord,
This is only adjourned, and this is a very simple issue. Let us decide this today. Yes.
judgment from the both sides on the last 3 offenses I have taken because it was listed not in the different.
Okay. No issue. These are not non-issues before this. Yes.
Here I am challenging the order dated my lord 11/1/22 passed by the my lord session judge, whereby the order passed by the my lord AGM. Now your lord 21st my lord the
Sorry to interrupt you, Lordship. We do not have any item.
No.
an FIR has been filed on 7/7/2015 on the incident of my lord taken place on 7/7/2015. But it will kindly come to the page 18 of the FIR. for the purpose of my lord, drawing up a proceeding under
This FIR was lost by
by the my lord, opposite party, my lord, opposite court.
Hmm.
My lord, there is absolutely no whisper in this particular my lord, affair with regard to my lord, breach of public peace or public tranquility, my lord, with my lord, ingredient mass, my lord. This is to send.
Okay.
Now, my lord, on the basis of this, my lord, not on the basis of this, my lord, and police report was submitted at page 22.
On the basis of this,
No.
they converted to non-FIR.
No.
Non-FIR case.
No.
No.
It is
Then
a-
on what basis?
my lord,
Non.
this has been registered as, my lord, Juliajan PS case number 285 of 15 under section 143, 150, 446, etc. And the investigation of the case is still pending. That reflects the police report itself.
This is the translation of page 20. Read the page 20.
This is also dated 7/7/2015. কর্মপূর্বক এই যে আজি 7/7/2015 তারিখে মোৰ নিজা নামত থকা মাটি ডাকঘৰ 192 55 এপি বৰঝাৰ গাঁও দুলীয়াজান নিজ ভূক্তফলত থকা দিনত প্ৰায় 3 বজাত হাল সামৰি ঘৰলৈ যাওঁ পিছত প্ৰায় 6 মান বজাত উক্ত দিনাই নিম্ন উল্লেখিত মহিলা কিছু পুৰুষ দুজনে ষড়যন্ত্ৰ কৰি মাটি দখল কৰাৰ উদ্দেশ্যে উক্ত জমিত প্ৰৱেশ কৰি বেৰ আদি কৰে কৰি অনাধিকাৰ
Translation is not as per the.
ইয়াৰ উপৰিও তেওঁলোকে অশ্লীল বাক্য প্ৰয়োগ কৰে মোক পিছতে প্ৰাণে মৰাৰ ভাবুকি দিয়ে গতিকে এই ক্ষেত্ৰত
So where are those translations? See your translation. Where is the attempt to kill? Where is the other allegation in your translation? And prayer also give me protection.
Yes.
Nothing is there.
I'm sorry, ma'am.
Is not it?
The same thing with the breach of public peace and tranquility is not indicated.
That is not in so many terms, but this pranemora bhabuki forceful disposition, it's definitely
So therefore this has been registered as a under different section.
because of this.
Look.
Okay.
So it is registered as the report, the police report you will also find at page 23. It is on the basis of another FIR that was lodged on 8/7.
Where is the affair?
But that is not there nowhere. It is not even in the written statement also.
Okay.
They are relying on this particular FIR of
Okay.
7/7. So, written statement, if you go to see, they are not relying on the FIR that was lodged on 8/7. They have relied on the FIR that was lodged on 7/7/2015, which does not indicate any of the ingredients of the breach of peace, if not public tranquility. Nonetheless, the cognizance was taken. The written statement have been filed. Evidence was recorded. The judgment was passed. Against that,
Is it necessary that you will have to disclose in the FIR that there is, because that is to be disclosed in the police report, which is at page 26. Just tell, just for our.
well, this is in respect of another case of the FIR dated 8/7. The report itself indicates it was submitted in respect of a case.
You want to say there are two FIRs,
two
7/7
FIR.
and 8/7.
Plus.
Okay.
So far as 8/7 is concerned, it was nobody's case. But then this report, is concerned with the FIR of 8/7. So we will kindly come for a moment, come to the written statement. They have filed. Written statement is at page 20.
29.
29.
Hmm.
That the first party is a true possessor of a plot of land measuring 11 bigger 4 kata 5 acres covered by document of AP number 54, situated at Boragadoi Gaon under Tipling Moja district Dibrugarh, Assam. That on 7/7/2015, the second party had wrongly entered and disturbed peaceful possession of the first party on the noted land by destroying boundary walls and disordered the land with pretense to peaceful possession and likely to committed a breach of peace and done wrongful act for which the first party apprehended to Duliajan station by a written Ezehar dated 7/7/2015. A copy of the Ezehar dated 7/7/2015 is enclosed here. That the first party has been physically possessing and cultivating the same on the said land since long time back, though it was recorded the name of Ganga Bishan Agarwala against the mentioned land in the AP
Just a minute, just a minute. You file proceed with your argument as per current, but you just two aspects you'll have to address. First is that this is a second revision. Okay.
It's not exactly second revision, it's just for it. It has a different ground, my lord.
No, we
It's
know
not
that. That's why. Let me complete. So this is a revision petition. And earlier was 437 maybe. Now it is under 397 401 maybe. This is a 482 petition. This is one aspect. So 482 petition. How far this court can exercise its inherent jurisdiction under what circumstances? This is one aspect. Second aspect of the matter is that there are concurrent finding of fact of quantum of factum of possession in favor of the first party. Now, this is so far relating to the possession. You can have still if you are the owner or if you want the declaration of your title is concluded by their possession. This is for the possession. You can very well file a suit. This is another aspect. And third aspect
Suit is already filed.
If suit is already filed, then what are we doing here?
So the status quo to be maintained and is subject to the method.
No, have you filed any injunction petition? So this is one. Good. Therefore, we will not like to until and unless you show those criteria are fulfilled. We will not try to reappreciate the evidence on the basis of which.
No, I'll not take the logic to the evidence.
Because I have gone through it. I cannot throw it away. I have gone through it. So whether any perversity is there in finding that finding to interfere. And if you have already filed a suit, then what remains here to be decided? Anything, any comment we make that may go against you also. Against him also.
Pursuant to the interlocutory order, none of the parties are. So that status quo is maintained.
No, why should you enter into exercise the power of a civil court? We'll just close it, and if you want to file any injunction petition, if you have filed, that will be considered as per law. And if you have not filed, still there is no problem. At any stage of the proceeding, you can file it. That I need not advise you.
Yeah.
You think over it. That's why I have asked these three questions.
The purpose of the wrong other tip is very
Okay, we'll address that. Yes.
That is the best. Why in between there is
So your basic thing is that the condition precedent for the satisfaction was not there. That was not recorded.
number one. And that is apparent from the because the police report concerning the FIR dated 7/7/2015 is not there. It is only in respect of an FIR dated 8/7/2015.
Suppose there is there is no FIR. Assuming for a moment. Now a police report is given. Thereafter, you participated in the proceeding. Evidences were taken. DW1, DW2, DW3 given. Then can we, until and unless he lacks jurisdiction, can we again re-agitate this? Until and unless if you say that no, this magistrate is not even having jurisdiction to entertain, or the session judge is not having jurisdiction. That is when it is a question of quorum non-juris, you can take at any stage. But this is not a question of jurisdiction. That is a question of how the order has been passed. That you have participated in all throughout, and this is in 145 proceeding. Isn't it? That's why I'm saying that this our scope is very limited in this case. Everything is done. Evidence taken.
But at one
PWC
stage, at
Ah,
one stage,
because the moment the cognizance or the proceeding or initiated with the basis of this report that there is no satisfaction while taking the note of this 145 proceeding. At that time, that this could have been a good case that see there is no satisfaction while accepting.
Once, my lord, the first round, my lord, the session judge has held that the
No, we understand that there was a remanded back.
well, no, my lord, it was my lord, the order was satisfied. Proceeding was passed, my lord, that one, but the session judge that was challenged before this court, and this court, my lord, after going through the my lord, various aspects of the matter, it has been found that along with the jurisdiction point, the other
No, not jurisdiction, that satisfaction. Jurisdiction they are having, but whether non-recording of satisfaction can be raised at this stage after wholly participating in DW1, DW2, DW3, PW1, PW2, PW3, all evidences are closed, and both the courts concurrently on the basis of this evidence came to a conclusion that it was a position is in their favor. Can we upset that findings? See, kindly see. Just I'll show you. We'll have to revise that. No, this is not correct. See DW1, DW2, what is their statements? So we'll have to reappreciate. That is one aspect. You argue, just I am giving my thought, just an idea. There is no bar that you will not argue. But tentatively, we are in under three conditions that is against you. You will have to pass this hurdle. First is that you participated in the proceeding thoroughly. That question of satisfaction position has been determined on the basis of the evidence material available on record. To reappreciate that evidence 482, what is our power to reverse that finding? First. Second, a 145 proceeding where 145 proceeding where already suit has been filed. And that decision will be taken if you are an owner. You recover, you will get a recovery of possession. That's all.
Not of the party, the government letter.
We have seen that. Somebody claims on the basis of a right of from Sangam Agarwala, and other claims on the basis of right of in the local people. These are done. Local people.
Both are claiming to be possession of the.
Both are claiming to be possession of the land.
Sorry.
If you are,
but initial order is bad.
Yes, you proceed. Yes. Yes. Then. This is initial order, na? Page 28. There's satisfaction. I am satisfied. Do I proceed in the
Page 20.
Yes. This according to you, there is no having no satisfaction regarding
which of
this anything is
which touches similar
the basic foundation. Therefore, all subsequent proceedings should fall.
And this is because, my lord, the FIR dated 7/7/2015, where it does not indicate anything. Now, regarding the FIR that has filed on 8/7/2015, it was nobody's case that there was an FIR in respect of the same incident on 8/7/2015. The written statement Lordship has seen.
Yes.
So very foundation, my lord, of the FIR, your Lordship will kindly come to the order passed by the my lord, court at page 34.
Yes.
page 34. First party is present, second party absent without any step, phase fixed for final judgment. The brief of the case is that first party Sri Ojit Borua filed a complaint on 7/7/2015 with OC Dudiajan police station alleging that the second party member about 930 disputed land with a view to grab the disputed land wrongfully and broke down fencing and damaged the property of first party. It is also complained that second party even abused and first party with filthy language, thereby threatened to keep him in fit. This complaint was the second line you will kindly find. This complaint was registered as non-FIR case number 14/15 under section 107/145. It is absolutely perverse because this report was submitted in connection with the FIR dated 8/7, which clearly reveals from the police report itself. The police report you will find.
Police report at 26.
At page 22.
22. Where in the vernacular? Page 26.
এই দুটাৰ সমূহ বিৱৰণ এই যে 8/7/2025 তাৰিখে, so it's a different affair. এই দুটাৰ সমূহ বিৱৰণী এই যে 8/7/2025 তাৰিখে দুচৰীয়া শ্ৰী অজিত বৰুৱা পিতা বশীধৰ বৰুৱা টিপলিং বৰগাধৈ গাঁও থানা দুলীয়াজান দৰখাস্ত দিয়ে যে টিপলিং বৰগাঁও গাঁৱত 3 দাগ নং 192 পট্টা নং 34 মুঠ 11 বিঘা 4 কাঠা 3 লুটা মাটি তেওঁৰ ভোগ দখলত আছে। 7/7/2025 তাৰিখে দুই পক্ষৰ লোকচান লগতে অন্যান্য লোকৰ সৈতে মিলি উক্ত মাটি সীমাৰ তাৰৰ বেৰা পকা খুটা ভাঙি মাটি দখল চেষ্টা কৰে আৰু একম পক্ষই জানিব পাৰিছে যে 7/7/2000 তাৰিখে একম পক্ষৰ ভোগ দখলত থকা জমি দখলৰ চেষ্টা চলোৱা লোকজনে দ্বিতীয় পক্ষ পুনৰ জমি দখলৰ চেষ্টা কৰিব পাৰে আৰু সাংঘাতিক ধৰণে শান্তি শৃংখলা ভংগ হোৱাৰ আশংকা আছে মতে লিখিতভাৱে জনোৱা তদন্ত কৰা হয়। So this is the second the FIR dated 8/7 where all these ingredients are there as per this report also. তদন্ত কালত জমিৰ পৰা জানিব পৰা যায় যে একম পক্ষই যোৱা 60 বছৰৰ পৰা উক্ত মাটি ভোগ দখল কৰি খাই আছে। একম পক্ষই উক্ত মাটি তেওঁৰ দেউতাকৰ দিনৰ পৰা ভোগ দখল আছে আৰু মাটিৰ যাৱতীয় খাজনা আদিও পৰিশোধ কৰি আছে। খাজনাৰ ৰচিদ দাখিল দিলো। অনুসন্ধান কালত জানিব পৰা যায় যে NR কেছ নম্বৰ 54/14/15 মৰ্মে উক্ত মাটি শ্ৰী গংগাৰাম আগৰৱালা পিতা মুৰলীধৰ আগৰৱালা গাঁও টিপলিং নামত আছিল আৰু এনুৱেল পাট্টাৰ কণ্ডিশ্যন ভাইলেট কৰি উক্ত মাটি একম পক্ষ শ্ৰী অজিত বৰাই ভোগ দখলত আছে বুলি উল্লেখ আছে। কপি এনক্ল'জ। অনুসন্ধান কালত দেখা যায় যে এই বিষয়ে তৎকালীনভাৱে আইনগত ব্যৱস্থা নললে যিকোনো সময়তে উভয় পক্ষৰ মাজত উক্ত জমি দখলৰ বাবে সাংঘাতিক ধৰণে শান্তি ভংগৰ আশংকা এটা প্ৰকট হৈছে। এই বিষয়ে তদন্ত কৰি জনা যায় যে একম পক্ষই আজি উল্লেখিত 4 মাটি ভোগ দখল কৰি খাই আছে। আনহাতে তৃতীয় পক্ষৰ লোকজনে বলপূৰ্বকভাৱে একম পক্ষৰ জমি দখল কৰিব চেষ্টা কৰাৰ সন্দৰ্ভত দুলীয়াজান থানাৰ গোচৰ নং 285/25 ভাৰতীয় দণ্ডবিধি আইনৰ 243 120 447 427 294 506 ধাৰাত গোচৰ ৰুজু হৈ বৰ্তমানে তদন্ত কৰি আছে। সন্দৰ্ভত স্থানীয় তদন্ত অনুসন্ধান পৰা জানিব পাৰি যে তাৎক্ষণিকভাৱে উক্ত জমিৰ ওপৰত আইনগত ব্যৱস্থা লৈ সিদ্ধান্তত উপনীত নহলে যিকোনো মুহূৰ্ততে উভয় পক্ষৰ মাজত বিৰাটভাৱে শান্তি ভংগৰ দাখিল কৰি উভয় পক্ষৰ মাননীয় আদালতৰ সমন মৰ্মে মাটি নি শৃংখলা অটুট তাৰ বাবে মুচলকা বন্ধ কৰিবৰ বাবে নিম্ন আদালতত চাৰিসীমাৰ জমি উভয় পক্ষৰ উক্ত নিম্লিখিত চাৰিসীমাৰ মাটি অহা যোৱা নিষিদ্ধ কৰি আইনগত ব্যৱস্থা ল'বৰ বাবে প্ৰাৰ্থনা জনালো। উভয় পক্ষক সমস্তে মাননীয় আদালতত মতাই সাক্ষ্য গ্ৰহণৰ বাবে প্ৰাৰ্থনা জনালো। So this is not clear that it is in respect of an affair that was lost, my lord, dated 8/7/2015. So far as my lord, the affair that was lost on 7/7/2015, the criminal case has been registered. Investigation going ahead with of having any report submitted for the purpose of trial of a proceeding under section 107(5). So therefore, the court could not have, my lord, taken, my lord, note of this report, my lord. Rather, it has, my lord, taken some other report which has, which does not reflect, my lord, any of the breach of condition. Because of this, my lord, the affair dated 7/7/2015. Now this order has been passed, and then the lordship has seen, my lord, the order, my lord. Now we have the boundary, my lord, is also, my lord, deformed. The police report boundary and the written statement boundary, my lord, are different. Now in the order, my lord, there is absolutely no mentioning of the boundary, etc., my lord. Now this order has been passed. Against this, we have approached the, my lord, session judge, and the learned session judge. The order does not contain, my lord, any boundary. Now in this revision petition,
Where is your boundary in your written statement?
is also not.
Then which will be accepting.
Both of them have not. But then, my lord, the report that was submitted, the boundary, that is not mentioned there, my lord, in the final order.
Yes.
And the order that has been passed, the lordship will see, my lord, at page 35.
Yes.
Page 35.
Yes.
Their main, my lord, our witness, my lord, that Gaum he has given a boundary. This boundary does not, my lord, is not the same that has been mentioned in the, my lord, police report, whose evidence has been relied.
TW?
He is court witness.
Court witness.
Court. Now this was challenged, my lord. The session judge has passed an order. You'll find page 40.
Page?
Page 40.
1440. 40.
From page 41, the revision under section 397, 319 of the CRPC is directed against the impeached final order dated 24/6 passed by the learned
This is the earlier proceeding.
But
isn't it?
earlier. The ground, my lord, that has been because the satisfaction was not there, it's nowhere there, and the very jurisdiction, my lord, could not have been, my lord, the magistrate could not have assumed the jurisdiction. For that purpose, it relied on various judgment also, my lord. So this was challenged before this honorable court. And this court, my lord, First in order, you'll also find page 46. Directly take a look to page 53.
Remanded.
Remanded. Page 50. The learned paragraph 13. The learned revisional court is found to have based its decision on the jurisdictional error of the learned additional district magistrate.
Paragraph.
Paragraph 13, page 50. The learned revisional court is found to have based its decision on the jurisdictional error of the learned magistrate, passing the initial order dated 10/7/2016. Although the respondent has a right to raise the issue of jurisdictional error before the learned revisional court, yet he could not.
Mr. Saikia, is it a question of jurisdiction?
Well, the
Is it a-
language of the various different states magistrate do not derive the jurisdiction to entertain.
So
It is not a
jurisdiction,
territorial
jurisdiction is two facts. One is the original jurisdiction and the jurisdiction to entertain. Other in the given background facts. Isn't it?
But a certain
So that
condition-
satisfaction even did not remain even after this order. That satisfaction is already there.
but that
Without its satisfaction, already matter has been proceeded. The learned court says, session just said that no, you cannot do this.
Yes.
That is set aside. But that has not been interfered by this court, saying that no, this is a issue of jurisdiction. Now, issue of jurisdiction will mean that he is not having a jurisdiction, or he is a error of jurisdiction, maybe a little bit, but it is anyway.
is the assumed jurisdiction by the magistrate only when this particular should be the one. The court not have disposed of the revision petition or without examining the merit of the materials before it. This is viewed by the Honorable Supreme Court in the case of Paul Supra. Therefore,
Okay, that was also a final order. Earlier position was also a final order.
first was my lord interlocutory order initiating the proceeding.
That you have challenged.
No, that interlocutory order.
No.
cannot be
First
challenged.
order was a satisfaction. Without having the satisfaction, they proceeded. Status quo has been granted to maintain status quo and to continue the proceeding, issuing notice to file written statement. That remained. Then you laid evidence.
My lord, this is an interlocutory order can be challenged.
Okay. No. Interlocutory. If you can, why cannot? Even it can be challenge under 482 if it is question of jurisdiction.
That is 482, my lord, but then the
Okay.
prescribed-
Anyway, we are not going back to that. Now, just I understand. Trying to understand. Then you proceeded. Then matter
proceeding concluded.
then in preferring the appeal, preferring the revision against the final order, you took amongst other a plea that it is not to be
Initiation itself was banned.
bad. That thing was negated by this court and remanded back the matter to the learned system.
No, this could not negative.
No, again asked to decide afresh.
This court says the revisional court decided the entire matter only on the jurisdictional issue, but then it was
Wait, he could have also decided on the
on-
merit of the matter as a whole,
Yes.
including the constitutional final order, which was in fact subject matter in the revision petition before him, particularly when the final order subjected to challenge in the revision petition was passed after full trial of including evidence of the parties. So what will you mean? So therefore it has been asked to decide on merit.
Yes.
So that portion that it cannot sustain on the basis of having no satisfaction is negated. Isn't it? Kindly read once again. He
Le-
could have also decided on the merit of the matter as a whole,
Yes.
including consideration of final order,
Yes.
which in fact the subject matter of revision petition before him,
Yes.
particularly, see this language, particularly when the final order subjected to challenge in revision was passed after full trial, which included the evidence of the both parties. So it says that since that what view I have expressed, there is you have participated, you have laid evidence, so let this matter be decided on merit. Accordingly, the learned session just decided on the merit. Isn't it? If you go by this language, isn't it? So what is the meaning of deciding an issue on merit when the same has been decided on the point of jurisdiction, as you say it? And that has been interfered and said that no, instead of doing this, you do on merit.
You don't do it on alone. You
Ah.
do it along with the merit.
So now,
Now they have done it along with the merit. This
Hmm.
is the point also. But for moment matter, I'm not going into the merit.
Ah.
Now, Malati, done it session judge
Hmm.
derived the satisfaction
Hmm.
not from the order itself, but he has gone to the report
Hmm.
and says in the report
Hmm.
these particular ingredients are available.
Hmm.
So the magistrate was right.
Hmm.
Now, as a divisional court, whether he could have substituted the
same happens here again. Same here happens here again.
it won't happen because what I would say, my lord, instead of going, my lord, to the police report,
Hmm.
which is again, my lord, in connection with another case.
Suppose there is no FIR. Suppose, assuming for a moment, police has filed a report saying that there is a likelihood of breach of and temporarily in view of this incident. There might be ancillary FIR or may not be FIR. Cannot magistrate take the, or should we go to the language only without recording to the going through the materials available before the magistrate?
What is some incident has happened, the police directly arrived at the spot and from there they have
But
made it
only for not recording satisfaction at this stage under 482, can we come to a conclusion that this report of police should be ignored, ought to have been ignored? And therefore, he has not assumed jurisdiction.
My submission would not be that, but my the state of going into the particular report,
Hmm.
it is again not in connection with
Hmm.
and derive a satisfaction like an appellate court.
Hmm.
The order prima facie reflects the very satisfaction of the magistrate is not there. The latent the material which is not on the record, which is not in the order, does not reflect, or not to have taken. Rather, the magistrate, the session judge would have remanded back the matter to decide the matter afresh, taking note of all the documents, material, whatever. Now here the revisional court acted as a exercises jurisdiction of appellate court, which is something different.
Yes.
If the
That is. Yes.
The power under 482 is very important. Now your lordship is exercising power under 482. To what extent 482 can be exercised when both the orders in his favor of me.
Where is the suit? Any material on the filing?
I do this suit. My learned friend. No, I don't know what happened.
Just a minute. Anything on material record here? Suit, filing of suit? No.
There is no material as such here. There is no material as such to say that there is a suit which has been filed. Maybe they may file a suit, but your lordship is here to determine respect of only possession. Well, preliminary report on a basis of police report. There is a proceeding which has been done on 145. Now, thereafter, written statement was filed. Thereafter, evidence is taken. What I am on, my lord, evidence is taken. What is the evidence that has been taken by the learned ADM? Your lordship will kindly has gone through it, all the evidence that has been taken. Your lordship has gone through it, all the witnesses that what the witnesses examined, only to that extent after taking evidence, then only a final conclusion has been drawn by learned ADM. Yes, the first party is in possession of the suit property. So, on the basis of the evidence that has been taken. Now, thereafter, what has happened? They came up before the learned session court. Learned session court has passed on in their favor. We came to the High Court. High Court said, no, the matter will be remanded back. Not only the point of merit has to be discussed. Now, kindly see the order passed by learned. They are agreed by that order. Kindly see page 66. 66, which they are aggrieved and they are before this court. 66, paragraph 12. In the instant case, it is seen from the evidence of PW before the learned ADM that the respondent was in fact in possession. Though DW2 stated that no one is in possession of dispute land, but he also went on to say that he used to cultivate on disputed land along with others, and the father of Ajit Bore used to take his share of cultivation. Admittedly, the petitioner's second party was never in possession of disputed land. Petitioner number 1, DW1 stated that learned ADM at the time the dispute land was used for holding Mohila Samiti meeting and their theatre, and that has been applied to allotment of the said land. This is important, my lord. That as per 145(1), the learned magistrate is to reach a conclusion as to who was in possession of the disputed land and whether anyone has been dispossessed within 2 months next before the date on which the report of a police officer or other information were received by the magistrate, or after that and before the date of his order under subsection 1. It is a settled principle that proceeding under 145 CRPC does not decide right title interest, and the parties are to approach the civil court for this purpose. As narrated herein above, disputed land is an annual patna land which stood in the name of one late Ganga Vishal Agarwal, allies to and so, but none has seen the later possess the said land. On the other hand, PW2, PW3, DW2 and court witnesses have stated the father of respondent used to cultivate the said land adhiya basis. Later, because of construction activities of oil, respondent has stated he has stopped cultivating. The court has no hesitation to hold that merely because the respondent was not cultivating the land for the past many years, it cannot be said the respondent was not in possession of the land. The court sees no infirmity in the final order passed by learned ADM, by which declared the first party would be in possession of the land, and further declared the respondent is entitled to retain such possession until outset by due course of law. So, what is the due course of law? Due course of law may be a civil suit may be filed by them. Now, till today, now, my lord, very interesting. I'll show one thing. Please kindly see page 38. Kindly see, very interesting, page 38. Kindly see. My lord, second paragraph. 2 other DW parroted the version of cultivation of so got it. Then after going to evidence, it is found the application of first party supported with revenue paying receipt. Proceeding of the cancellation of AP initiated by CEO Tengaghar after following the prescribed procedures such as having the reports of Gambura, SK and Lot Mondal sent to DC for starting NRA case, and the AP is cancelled. Report of the Gambura and Lot Mondal and SK squarely scores first party is in possession of disputed land. So the police report. The DW1 stated that the CEO asked them to occupy the land, and he will make document for them. This statement shows that on the date of occurrence, the second party has no possession over the disputed land. The said DW also stated that when they asked Ranjit Tambuli why the ploughing and fencing done by him, he informed the land has been sold to them by first party. This statement also showed the second party was not a possession at any point of time, and at day of occurrence, the person claiming under first party was ploughing and fencing the disputed land as per instruction of first party. Till then, the second party have no existence on over the disputed land. Moreover, the second party have no legal existence as of alleged Mahila Samiti, nor they file any document to support their case, even in a minuscule probability. And top of all the irregular use of the dispute land alleged is also not supported by other DW, and the same cannot defeat the statutory provision of Assam Land Revenue. So and so. Under this circle, I do hereby declare first party in possession of the state. This has been affirmed by the learned session court, while this court has again remanded back to the learned sessions and decide on the facts of the case, and accordingly it was decided by lord. Now, my lord, your lordship will kindly see in 145 proceeding, the evidence has to be looked into it. Now, I'll show one judgment regarding about 145. Yes, kindly see, my lord. Our High Court decides Madhu Sharma and others versus Ajit Sharma. Now, para 20. Para 20. See para 21. Section 145 is within chapter 10 of CRP, which deals maintenance of public order and tranquility. Particularly, the object of section is to maintain law and order and to prevent a breach of peace by maintaining either one or other of the party in possession just 2 months immediately before the report submitted by the police officer or the informant regarding the dispute likely to cause breach of peace concerning the land in dispute. And not only that, in 145 proceeding, the magistrate cannot inquire the rights of the parties so far as title of the land is concerned. He can only decide the question of possession, and while considering the possession of the dispute land in question, magistrate has to consider the evidence adduced by the party in the proceeding. Even dispute between the parties regarding the possession of land would not come within the purview of section 145 code unless there is likelihood of breach of peace and there is no material before the magistrate which suggests likelihood of breach of peace. And if there is no material before this so and so, which suggests then the proceeding would be without jurisdiction. It is also said likelihood of breach of peace should not only be existed on date of application, but also on the date of preliminary order passed by the magistrate. So on the preliminary order passed by the magistrate, there exists a breach of peace. So the evidence was taken, the court below, the ADM has taken into consideration, my lord, and only thereafter this order has been passed. So this is one, my lord. Another, my lord, you'll kindly see. What the principle to not only judgment of the Supreme Court, 1988, 4 SCC 452. Kindly see paragraph 8. What your lordship expressed, that if you really agree, go before a civil court, agitate that point before a civil court, you are in possession with the papers, you have got right title interest over their property. Paragraph 8. We fail to understand how the High Court in case took the advantage of decision of the court in Ramstumar case. Ratio in the said decision, the party should not be permitted to litigate before a criminal court when the civil suit is pending in respect of the same subject. Here, my lord, what has happened? It has gone before a criminal court first. That is 145 proceeding, man. Now, this does not mean that a concluded order under 145 CRPC made by the magistrate of competent jurisdiction should be set at naught merely because the unsuccessful party has approached the civil court. An order made under section 145 CRPC deals with only with the factum of position of a party or as on a particular day, which has been done. The learned court, both the judgment by the ADM as well learned session court, factum as a position has been decided.
Yes. That's all.
This is last judgment. That's July 2012, 3 GLR, page 616. Reiterated Supreme Court judgment, para 17. You all note down para 17. Para 17, you all just note down para 17. Reiterated judgment of the Supreme Court. So my humble submission before your lordship is that there is no question of a status quo. It is only in respect of possession, and it has been declared by the court by the ADM, which is confirmed by the learned session court, which were the demand. So that status quo order should go, my lord. And if anyone is aggrieved, let them go for civil court. Let them get an order from the civil court, not from this court, the status quo order. That's my humble submission.
I have a good maintain on this jurisdiction part, but the court did not have the materials before it. And my lord, now
According to you, a satisfaction is sine qua non for proceeding under 145.
now I'll submit it.
And that satisfaction was not reflected in the first order.
Yes, that is he is the authority to derive that kind of satisfaction. Not
That
that he revision
without
or
that
the appellate court.
satisfaction, he could not have
Could
proceeded.
not have proceeded.
Since he has proceeded without that satisfaction, so entire subsequent things being nullity will fall. What is your?
On that, my lord, the 2008 one dealer 57.
2000, just a minute. 2008, 1 GLR,
57.
576 page, paragraph
Paragraph 9, 10, 11, 19, and 20.
9, 10, 11, 19, and
20.
20. Nine, 10, 11, 19, and 20. 11, 19, 20. Okay.
The same point, my lord. 1992 DLR 29.
Same point, na?
Same point.
1992,
DLR
2 GLR,
29.
1919, volume 2.
1990
1990, volume 2 GLR,
page 29.
page 29, paragraph
Paragraph 6.
6. Then
Then my 2007 4 GLT
2007,
4 GLT
4 GLT,
889.
page, paragraph,
Paragraph
page 89, paragraph,
Page 889. Paragraph
page 889. Okay.
88.
Hmm.
Paragraph 6, 7, 8, and 9.
6, 7, 8, and 9.
So these are on the same issue that the
Satisfaction was not.
satisfaction is a condition precedent it passed. Now with regard to the interrogatory order as it is does not provide it marks with the final order, so it is valid. On that point the justice is there. But so at the time of the final order, so it is
That should be considered.
so it's preliminary order and the other one is called final. So that order marks with the final order. So therefore, if that jurisdiction point or this expectation can be raised according to it has been raised. Now, my lord, what is the status of that, my lord, the preliminary order, my lord, the interlocutory order? So on that, my lord, I will submit, my lord, AIR 1980, Supreme Court 242,
AIR,
1980, Supreme Court
AIR 1980, Supreme Court
242,
242,
paragraph 37.
paragraph 37.
The gist of the paragraph is that a preliminary order is considered so basic to a proceeding under section 145. Several high courts have held subsequent proceedings in basis.
Okay, paragraph.
Paragraph
37.
4.
Paragraph.
Paragraph 4.
AIR 1980, SC 242, paragraph.
Paragraph 4.
4.
Then, my lord, 2011 3 SCC
2011 3 SCC
436.
436.
Paragraph 37.
Paragraph 37.
The gist of this paragraph is it is a subtle legal position that an order is bad in its inception, it does not get sanctified at a later. Order is bad at the initial stage, it cannot be sanctified at a later. My lord, regarding interlocutory order, already I have said, but I had several judgments are there.
Not necessary.
So, but here, the court has passed the order, my lord, on merit. I have not argued on the merit certificate that I feel that the magistrate is satisfied that the materials are available to derive the satisfaction. The magistrate ought to have derived the satisfaction
From the report or
from the
any
report. And for that matter, would have, my lord, remanded back the matter to pass an order afresh. So that is my, but then the magistrate, the session judge could not have, my lord, taken the jurisdiction of the, my lord, court in a sitting in a, my lord, revisional court and substitute its own satisfaction and own fine. And that too, my lord, on a report from the very, my lord,
say FIR is something else, report is.
FIR is nobody's case. Even in the written statement, the opposite party, my lord, has never uttered a single word that they have filed an FIR on 8-7. It is on the basis of the 7. Where from this case, my lord, says
It has come, there is nothing.
nothing much. So when that FIR is not exhibited, when the report does not, my lord, it cannot be taken into consideration. It is very much correct, but if the police would have submitted a report of it, so what would have happened? That is a different case. Had it been there, my lord, then police.
According to you, whole proceeding is initiated on the basis of an FIR. It is not a case that it is on the basis of the police on its own.
Yes,
So therefore, there is a relevance of that FIR which is not even available on record.
and it is nobody's case even when the opposite party did not set up that case. Then on subsequently on 8/7 they have filed an FIR pursuant to that. This has come.
Okay, just a quick answer to my learned friend about preliminary and the final. But when the preliminary order was drawn by the magistrate on the application filed under 145, that time they did not challenge the preliminary order.
Well, there's no
If that,
forum.
1 second, let me. If that preliminary order was not put to challenge, my lord, kindly see the order, again the final order they come and they challenge before learned sessions court. Not against the preliminary order. You could come and challenge the preliminary order when you are not satisfied. Only when the final order was passed, when they have gone against them, that's what the judgment says. Case 41, they have come against final order, not against the preliminary order. And that has been well explained by the learned sessions court while deciding the matter against them.
Hearing concluded, please this matter for delivery of order on 28th of November 2023.
Deputy Officer.
Change it to your change.
40.
Over. List over.